All right. We got another video. We almost done with the second part of Article 1, Part 2. Let me go. Article 1, Part 2. Yep, so principles of interpretation. So presumption, right? So I thought this is a great section to dive deep into what government means, right? And I say that because the whole reason government exists is in that definition of government, right? And so I looked it up, so let's go find it. All right, so government. This is Congress's, the judicial branch and the executive branch's whole intent when they're doing acts, right? All right, so the regulation, restraint, supervision, or control which is exercised upon the individual members of an organized jural society by those invested with the supreme political authority for the good and welfare of the body politic, or the act of exercising supreme political power or control, right? So let's start right there. So the government governs us. They get consent to have supreme political power or control over us by our consent, right? But that Constitution is the buffer, if you will, between us and them. Okay, not that it's a battle, not that it's two people against each other, but it's a buffer, if you will, because the Constitution was written to protect our liberties, right? Read the preamble, right? And the government's supposed to be there to help us do that. Okay? So, but look what they're doing when they're governing us. They're regulating and restraining stuff, right? So our liberty to make our own choices is the fact of not having that upon someone, right? No regulation, no restraint, no supervision, right? All right, but that doesn't mean you can just go around causing harm and damaging people. All right, so let's read presumption. All right, so whenever the Uniform Commercial Code creates a presumption with respect to a fact, right, or provides that a fact is presumed, the trier of fact, meaning the judge or the jury, right? Because when the whole reason this law is coming into being is to govern, to restrain something, right? So in order to litigate something, right, you have to talk about the facts, right? And only the people that were actually harmed or were in this scenario know the facts, right? The judge doesn't know the fact. He hears it. He's the trier of fact. If he can't make a decision, he has to put that off to the jury to decide. Okay? All right, so provides that a fact is presumed, and the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. Right? So when something's presumed, or the Uniform Commercial Code, or in case law, some act or conduct, remember, because we're talking about transactions, right? So some act or conduct that somebody does, and a fact is presumed because of that, or because of something they did or didn't do, or, you know, that causes a presumption. Because remember, the judge, the jury, all these triers of facts, right? They weren't there, right? So we can only presume as third parties looking in your situation, okay? So that's why it's good to be a storyteller, because it helps you explain to these people that weren't there what the facts are, right? And you work that through presumptions and through circumstances and through facts and through conduct, right? So what is this person doing? What are they saying? What are they not doing? What are they refraining from doing, right? All right, so that's a presumption, right? And I wanted to read this last thing that kind of ties into this too. It opened my mind so much with contract law. Okay. So this is a document talking about acceptance and contract formation, right? So I thought this was so amazing when I read this. All right, so this section is talking about acceptance, right? See it in bold up there, acceptance. So this is talking about acceptance by silence or exercise of dominion. Okay, so when an offeree, right? So that's someone who's getting an offer put in front of them, right? Takes the benefit of offered services with reasonable opportunity to reject them and reason to know that they were offered with the exception of compensation, right? Which means, hey, I got this offer on my desk and someone's expecting something in return for this, right? When the I'm supposed to read the top. Oh, wait, I read it. Okay. So where an offeree fails to reply to an offer, his silence and inaction operate as an acceptance in the following cases only. Right? You hear that? So when the offeree, someone that gets an offer on their table, they will fail to reply to an offer, by the fact that them not saying nothing or not doing nothing operate as an acceptance in these scenarios, A, B, and C, right? All right, so when an offeree takes the benefit, so when they get a benefit of something, when they know daggone well that they could have rejected it, and they have reason to know that the person who offered it to them expected compensation, that's considered acceptance, right? They knew that a payment was supposed to be made, and they knew you expected to get something from that, but they didn't reject it and they didn't say anything about it. But they got the benefit of that payment or whatever, right? All right, so number 2. All right, so let's jump to 2 because this is the main part, right? So number 2, this is an extension of acceptance by silence and exercise of dominion. So 2, so an offeree, the same person, right, who does any act inconsistent with the offerer's ownership of offered property is bound in accordance with the offered terms unless they are manifestly unreasonable. But if the act is wrongful, right? So if they, let's say you give somebody something, right? You expect a compensation or something in return for that, right? They don't reject it. They don't accept it. I'm sorry, they don't reject it. They don't say nothing about it, but they don't give it back to you, right? Because it's not theirs, it's yours. Because you're the one who offered it to them as the offeree, right? But they're doing something in adverse to your ownership, right? So let's go. Where's it at? So an offeree who doesn't act inconsistent with the offerer's ownership of offered property is bound in accordance with the offered terms unless, right? So the offeree is bound, right? When they're acting like they own this shit, but really they don't, right? They're bound by those terms unless they are manifestly unreasonable. Unless it's just something like, no way, like, no, all right? But if the act is wrongful, what the offeree is doing as against the offerer, it is acceptance. Only if ratified by him. Now this is the key one. This is the key. Right? So if they take your property that you offer to them, that you expected something in return for, and they don't give it back, they just keep it, right? That is considered wrongful, right? Against you because you offered it to them and it was yours, and it's considered acceptance. Only if ratified by him, meaning the offeror, right? Because that's the one that's the wrongful act is happening to, right? So ratified, let's look that up, right? Ratified. This is the key one, right? Let's ratify. Okay, ratified, right? Ratification. The confirmation of a previous act done either by the party himself or by another confirmation of a voidable act. Right, let's go to, hold on. To approve or enact a legally binding act that would not otherwise be binding in the absence of such approval. Right, so unless you say it's wrongful, because they're legally binding now, right? It's not otherwise binding. In the absence of such, you're proving that it is wrongful to you because they just took your property, right? Presumption.